Gentlemen, welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issue of politics, law, and governance. In today's episode, we'll look at two interesting topics that have emerged during the week. First, we'll look at the suit filed by Mr. Oko in the motion where he challenged the inauguration or the appointment of 12 justices of the Federal Capital Territory. And in that suit, Mr. Oko has sued Baba Yusuf, the Chief Judge of the Federal Capital Territory, the NJC, and the Federal Judicial Service Commission. He also joined on the suit the CJN and the President of the Federation. The plaintiff have sought an order directing the parties to maintain status quo. The gross of his suit is that he hailed from Ebonyi State and no judge from her state was appointed, which he felt that was an injustice meted on his on Ebonyi State. And that as one of the states constituting the 36 states of the Federation, that his state has a right to also be represented in the Federal Capital Judiciary. So we'll look at that. And our second topic today, we'll also look at the dollarization of the economy. Over the years, we have been inundated, with the issue of inflation, the issue of floating of the naira in order to give the fair value of the dollar and the naira. And we have had a series of policies being implemented by the Central Bank of Nigeria to curb, the rising inflation. And one of the issues that so many people have pointed out that is at the root of this inflation or the demand for dollar versus naira is the dollarization of the economy. And one would wonder, what is dollarization of the economy? Dollarization of the economy in this sense is simply the utilization of dollar by individuals and institutions alongside the naira in the economy to value transactions and for the purchase of goods and services. Of course, the CBN Act of 2007 has specifically mentioned that the naira is the only legal tender that is acceptable in the country. However, it has been discovered that certain individuals and institutions now accept dollar for transaction, which has indeed impacted the demand for dollar, thereby leading to scarcity of dollar and causing inflation in the economy. Bearing in mind that our country is import dependent and we utilize the dollar for some of this import. So we'll look at the implication of the dollarization of the economy vis-a-vis the laws of the CBN in this regard. So we'll go on a very short break, and when we return, we'll introduce our guest who is already seated in the studio this afternoon to help us explain some of this topic better for better understanding. My name is Kenneth Mimo. Stay tuned. We'll be back very shortly. Welcome back. If you are just joining us, you are on to your favorite program, Democracy and the Rule of Law. With me on this show this afternoon, we have Barrister Obiora Ume, a respected legal practitioner. Barrister Obiora Ume, welcome you to the show this afternoon.
Thank you very much.
All right, so we'll go into the middle of this show this afternoon. So our first topic is we'll look at the issue concerning the suit challenging the appointment of about 12 justices of the Federal Capital Territory by one Mr. Oko, who is from Ebonyi State, challenging their appointment and seeking that the court should suspend the inauguration or appointment, pending the determination of his grasp, which he feels that the appointment was in contravention of his of the Constitution, especially the Chapter 2 of the Constitution, which talks about justice, equitable, and all of the appointment. So he cited some example of injustice. For instance, he said that some states have about 2 justices at the FCT High Court. For instance, Kogi State, they had 2 justices already in the FCT High Court, and there is another one who is going to be appointed among those who is seeking that they should pen their appointment, so making it 3, while Ebonyi State, which is a bona fide member of the Federation, has none in the FCT, judging in mind that FCT is for everybody, every state ought to be represented. So he has gone to challenge this appointment in seeking for equity distribution of these offices. So what do you have to say concerning all of this?
All right, thank you. Looking at the matter they has taken to the court, he sued the Chief Judge of the Federal Capital Territory, the CJN, the Attorney General of the Federation, the President, and others. And in as much as one, we have to look at his complaints, so to say. Is the complaint genuine? That's one thing to look at. 2, the modality of seeking the reliefs that are contained in the originating process. Looking at the modality, he went to the court in Abuja, asking the court first to stay the inauguration of the appointed judges. In fact, Justice Eko, who is handling the matter, when the application came before him, it did not grant it. Meanwhile, the age of the Federation, the CJN, and other respondents filed preliminary objection to the competence of that suit. The grounds of the objection is to the fact that these judges, or the people appointed as judges, are by necessary implication and intendment offered employment by the Federal Capital Territory as judges. Now, even though it is controlled by the Judicial Service Commission and other agencies that are involved in the appointment of judges, but it has to do with employment. Now, they are saying, which I tend to agree with, that under Section 251, 1C of the 1999 Constitution as amended, everything that has to do with employment is within the exclusive jurisdiction of the National Industrial Court. Which means that if you have any grounds concerning employment, the proper venue for the ventilation of your complaints and grievances is the National Industrial Court, not the state or federal high court. What that portends is that he may have a genuine complaint, but he has gone to the wrong place. That's my personal view, and that is the basis of the objection raised by the AGF and other respondents in that matter, including the objection by the CJN. Now, in 2020, a similar suit was filed, and it was dismissed. So, looking at the matter holistically, I agree that in matters that concern the nation, there should be fair distribution of whatever inures to the nation as a nation to the respective states of the Federation. Presently, we have 30 states and the Federal Capital Territory. The grounds of Azubike Oko is the fact that his state, Ebonyi State, does not have a single judge at Federal Capital Territory.
Yeah, sorry, does all states have judges?
And that some states have more than 2 already. He has a genuine complaint. He has a genuine complaint. What is genuine complaint? Since in the eye of the law, no state is greater or higher in status than the others. There should be fair distribution. If some states already having 2 judges and now they're having 3 and the boy does not have anyone, in the eyes of the law, it does not appear to be fair and equitable. The federal capital, the federal government has a law which says that in the issues of the Federation Nigeria as an entity, that when making appointments, take such appointments across the Nigerian globe. Don't pigeonhole yourself into just one area. And that is why in the issue of appointments by the president, he looked at the federal character and ensured that there is fair representation of the people that make up the nation, especially from the 36 states of the federation. So coming to that, I agree that if Ebonyi State does not have a representation at the Federal Capital Territory Court, there is need for that state to have a representation, to give that state a sense of belonging. But then, like I said earlier, that there are 2 issues we need to look at. The issue of the complaint, is it genuine? Is it something? Is it justiciable? And then the second leg is the modality, the approach he has adopted, the court he has gone to. Because we know that things that gives the court jurisdiction, gives the court the power to look into a matter and decide that might determine it, is one, whether the subject matter is one of the matters the court is authorized by law to look into. Courts of law, especially courts of record, in fact, of course, are given their powers, their jurisdiction by statute, by law. And no court will exercise any power not given by any law. And since the court he has gone to is not the court that has been enjoined by the Constitution, which of course is the ground norm, the supreme law of the land that binds everybody, the court he has gone to is not the court that has been given the exclusive powers to deal with that subject matter. Then I think he has gone to the wrong venue. The locus classicus is the case of Madukolo and Kemdilim, where the Supreme Court by FJ in 1961 laid down what gives court jurisdiction. Part of which is that the parties must have come to the court, and the subject matter within the jurisdiction of the court. The subject matter is the issue of employment of the 12 judges by the Federal Capital Territory. Like I said earlier, the issue of employment is within the exclusive jurisdiction of the National Industrial Court. So he has gone the wrong venue, and of course, the court has taken agreement from counsel to both parties and has reserved judgment for 15th of March.
All right. So, but apart from the fact that he has obviously gone to the wrong court, but let us talk about the justiciability of his claim. All the states, we have 36 states of the Federation. Mm-hmm. So are all the states, by law, would they be represented as the FCT church? Do we have a vacancy for up to 36 judges of the FCT?
Presently, I do not think that there is enough hands to get up to 36 judges for the Federal Capital Territory. But then the issue of justiciability is, one, is it something that the court can entertain? Yes. If someone has a genuine complaint, the court can entertain it. But so the issue of justiciability, yes, is justiciable, but he has not gone to the right court. That's number one. Number two,
So if all states start going to make sure that they have somebody, since we do not have up to, you can imagine all the states going to the Supreme Court to say that they need a representative there. There are no modality for this appointment, and if your state doesn't meet that criteria, obviously all states cannot sit on the bench of the FCT, because there are no vacancies for 36 judges to sit. So obviously some states are going to be left out in the representation there. So is it compulsory? Because he is basing his argument on the law. Is it compulsory that all states, or even Ebonyi state, must have a representative, at the FCT? Yeah.
Well, since the matter is still before a court, all we need to do is to watch what the court is going to come up with. But looking at your question, whether it's compulsory, in the issue of appointment of judges, there are certain things that are usually considered. Number one, the competence of the appointees. And then, if you talk of competence, the person must be a lawyer, that's the starting point, must be knowledgeable in the law, and must be able to do justice, at least as far as the society is concerned. So, is Mr. Azubiko Oko, who went to the court, is here to tell the world, and Nigerians in particular, that he is qualified,
or that the people,
or that there are people that are qualified in the state but were not given the opportunity. He didn't say that, and he has not come to impugn the competence of any of those that were appointed. He even wanted to court to stop the inauguration, the swearing of those judges, which I believe was going too far. So now he may have drawn attention to the fact that in appointments, consider other states. Actually, during the era of Buhari, there was a time that there were appointments of judges to the Federal High Court. And some states were given 4 judges at that time. Some were given 3, some were given 2. There's some parts of the country were not giving anyone, not even single one, and they were raising eyebrows. But then it came and went. So I believe that for the interest of the unity of this nation, that in the appointment of judges or whatever appointment it may be, let there be fair consideration of all the stakeholders, because all the state of the nation are stakeholders in the unity of the nation. At least we all want this nation to remain one nation, and to that extent there should be fairness. Yes.
Okay. There should be fairness.
Yes.
And of course, all states may not. Of course, the NJC has a criteria which they use
exactly
appointed people.
Yes.
And from Azubike Oko's suit, he had not said that those procedures were breached.
Yes, he had not said so. And they also not say that his governor, the governor of Ebonyi State, recommended somebody who was not even considered. Yes, he had not said that much.
The major grounds is that somebody from his state, Ebonyi State, was not considered.
Yes.
That you people, that they must appoint a judge from his own state.
Yes.
For his mind to be at best. But moving on from there, let's look at, because the court has also said that he lacked the local standard to even institute that action, that he was not...
No, the court has not decided the matter. It's coming up for judgment on 15th, this week.
Oh, okay.
It has not been decided yet.
Yeah, I think...
but they are challenging his... yes, his legal standing to sue. They are challenging his legal standing to sue.
So Mr. Oko, does he have as a lawyer, does he have... I think the other party is challenging the local standard.
That's on the local standard.
He was not
also asking whether he has gone to the right place to ventilate his grievances.
So can anybody sue on the issues like this, or the law doesn't give rights for anybody, even when you are not a party to the process? You know, is it a public interest litigation suit? Or, because I'm sure people want to know.
Yes, you see, the fact that he has gone to court and is challenging what he believes to be a contravention or non-conformity with the provisions of the Constitution, I believe he has a right. Because the narrow compass of local standard, as we had it then, has been widened. You know, if you remember the case of Fawemi and IGP, the Supreme Court of Obaseki said that everybody in Nigeria is his brother's keeper. Because Fawemi at that end was spiritedly fighting for justice for the slain Delegewa. He wanted the police and all the law enforcement agents concerned to unravel the mystery behind the bomb blast that sent Delegewa to an early grave. And then Fawemi was challenged that what interest has he got to sue for the authority to be to investigate and prosecute the killers of Delegewa. And the Supreme Court here, you see that in Nigeria everybody is a brother's keeper. So to that extent, I agree that he has the powers, he has the locus, and he has the standing. If the Constitution, or any part of any statutory law has been breached, that I agree. But then the issue is having a standing to sue, and at the same time, of course, the people on the other side of the Great Divide will tell you what does it stand to suffer by the appointment of these 12 judges and non-inclusion of somebody from his state. He's saying that, look, the law says that my state should or ought to be represented at the judiciary of the Federal Capital Territory because the Capital Territory is for all Nigerians.
And the Federal Charter Principle.
Yes, yes.
Okay, let us even move away from this, because the issue borders on the issue of equity
and fairness. Yes. What is good for the goat should equally be good for the gander.
We believe that we are running a federal system of government.
Yes.
Because we have also had complaints during the appointment of ministers.
Yes.
Where some section of the people have complained that the portfolios or the appointments were not evenly distributed.
Yes.
That some states had about 3, had more than 1. Some only had 1. Some had as much as 3. I don't even know if some had as much as 4. And there were a lot of complaints. So what do you have to advise in the issue of equitable distribution of portfolio, or should we just go for competence, even if the people who are competent come from a particular state, and we have 10 competent people there, we can go with them instead of this distribution of appointments?
You see, the Federal Charter principle is that there should be fair distribution. And why was that put in place? To give everyone in Nigeria a sense of belonging. If, as a leader in any capacity, you limit your appointments to a particular section or group of persons, it will be lopsided. It will look as if you are favoring one side to the detriment of the other side. And that is why, the founders of this nation thought it necessary and fit to ensure that in appointments and allocation there is fairness, equity, and justice. To that extent, both in appointment of judges, in appointment of ministers, and whatever thing that needs to be done, there is need to ensure that the states, if there's a no vacancy, the states are represented. And of course, it will be a blind argument to say that in the whole of Ebonyi State, there is no single qualified person to be appointed as a judge at the Federal Capital Territory.
Yes, but if I get you correctly, people have compared our federalism to that of US, where it doesn't really matter where you come from. Nobody mentions which state you come from. What is actually being emphasized is competence and merit, you know, to what we have in Nigeria. And now we are talking about restructuring merit-based system. And some people have also argued that one of the issues we have in the country is this allocation of portfolios. You know, we do not go with the merit-based system. So should we still continue with this allocation of portfolio even when we do not have qualified people in some region? We must, or should we go with merit-based system as practiced in the US, where you can even appoint your son if he knows he can get the job done?
You see, we cannot approbate and reprobate. We must stand somewhere. And in this country, Nigeria, where the nation has stood over the years, is that in distribution of portfolio and appointments, there must be fair representation of the various entities they say that make up the federation. That is not what is practiced in US. But in Nigeria, that is what is the current position. So long as that is the position, there must be compliance. Otherwise, people like Azupike Oko will go to court or go to the public to say, look, we are being neglected. You discover that over time, before now, there have been cries from some sections of the country that they were being, you know, neglected, that they are being, you know, denied some of their rights and so on. So they were trying to say, okay, let there be a balance. So long as we are not pressing what is obtainable in America as far as the issue of appointments is concerned, what we've been pressing over time is, in the various places, get the best, get the competent ones in the various states. Of course, nobody is saying that appointment of the is not competent. We don't believe in having a round peg in a square hole. So long as there are competent people, appoint them and let there be fair representation, because we all come together. As we come together, it will not be fair for only one person to now say, well, in my area I have 10 competent people, say it brings in the 10, and others, well, let them wait until they are qualified. That would not be fair. And that is why at the National Assembly you have representatives from all the constituencies, both as in the House of Representatives and in the House of Senate. They are representatives. No matter which section you come from, you have somebody who is representing your interest at the National Assembly. Whether the person is actually doing it or not is a discussion for another day. So long as that has been captured by the Constitution, is encapsulated there, and is being practiced, let us apply it in other areas. Let it not just be that if somebody becomes the president, he now looks at his people, maybe his political affiliates, people that supported him, and start dishing out appointments to them. That is not what Constitution says. That's what we believe in. We believe that whoever is there, you are there as the president of a nation, not a political party or region. That is what we believe in. And that's what the nation stands for. So to that extent, Nigeria says, let there be fair representation. And that's what equity and justice demands.
All right. We cannot approbate and reprobate at
yes.
the same time.
Yes.
We must always stand for one thing at a particular time.
Yes.
Our guest in the studio has advocated for there to be equity and fairness in the distribution of position, because that is what our Constitution says at the moment.
Yes.
That must be obeyed.